Welcome to the McNees Labor and Employment Podcast Series. This podcast will address 5 steps to effectively manage workers' compensation claims by Denise Elliott, attorney at law. Ms. Elliott practices in the Labor and Employment Group at McNees.
Welcome to the final installment of our 3-part series discussing the 5 best practices to effectively manage workers' compensation claims. In Part 1, we discussed the web of benefits available to injured workers and the first of the 5 steps, looking at the big picture. In Part 2, we discussed working with adjusters to investigate and decide on claim management and how to effectively utilize nurse case managers. In this installment, we will discuss when and when not to terminate employment and looking for creative settlement solutions. Regarding termination, some employers are gun-shy about firing an injured worker. Others are too quick to terminate and run the risk of a companion wrongful termination claim. So how can you find the happy middle ground? One of the top questions I'm asked by clients is, can an employee be terminated while on workers' compensation? The answer is yes, provided that the termination is not retaliatory, does not violate state or federal law, and is not in violation of the employer's policies. When considering termination, create a checklist. First, did the employee violate a policy or work rule? And if so, what is the violation? Did the employee fail a drug test, violate your no-call, no-show policy, violate a safety rule, or repeatedly fail to meet production requirements? Second, is the documentation of the rule violation in order? Can the violation be proven? Third, is termination for such an offense consistent with your past practices? If yes, then such rule violation should not be ignored simply because the employee has claimed a work injury. But what if there is no rule violation, yet you feel it's time to terminate? First, ask whether the employee is FMLA eligible. Remember, eligible employees are entitled to 12 weeks of job-protected medical leave and should not be terminated, absent a rule violation, during those 12 weeks. Second, do your policies provide for any type of extended medical leave? If so, you must comply with your policies. Third, if the employee has exhausted his FMLA and any supplemental leave, remember your obligations under the ADA. Would some accommodation help get the employee back to work? Lastly, consider how termination will affect claim management. If you want to be able to offer the employee a light-duty job once released to work, then it might be premature to terminate employment. In all cases, the best practice for any termination is careful documentation. We also strongly suggest that decisions be made with the input and guidance of counsel due to the risk of companion claims. Remember, an employee who is disgruntled already due to a bad experience with a workers' comp claim is more likely to sue you for ancillary claims. And the final best practice for effective claim management is look for creative settlement solutions. Settling for a simple lump sum just doesn't always make sense, so it's important to think outside the box. For example, if your company has an early retirement option and your employee is eligible, you could structure a settlement so that the employee can retire and receive retirement benefits. What if you insist on resignation as part of the settlement, but the employee is insistent on having continued health insurance? You could always agree to reimburse the employee for COBRA payments for some period of time. Some employers simply dislike paying out a large lump sum, but don't mind paying for medical care an employee may need. If that's the case, the wage loss portion of the claim can be settled for a small amount, and we can leave open the employee's entitlement to medical benefits for some set period of time. It is also vitally important to negotiate a broad employment release agreement whenever a workers' comp claim is settled. You do not want to pay out tens of thousands of dollars on a comp claim and then get hit with a federal ADA or discrimination suit simply because you were narrowly focused on the workers' comp issues. It is always best to consult an attorney well-versed in both workers' comp and employment law prior to and during settlement discussions. Attending settlement conferences and mediations is also a best practice. Managing workers' compensation claims can be complicated, but the process can still be used as it was intended a century ago. And utilizing the 5 best practices we've discussed will certainly help. But should you want more information about managing workers' comp claims, feel free to contact me at the number on your screen.